Hi, everybody. One of the most common questions that I get from my clients is how do I keep things simple, manageable, easy for my beneficiaries after I pass away? And in my world, simple and easy typically translates into let's keep assets outside of probate. Because while probate does serve a really valid purpose, it makes sure your assets get to where you said you wanted them to go. It's a lengthy process. It takes at least a year, maybe more. So why put your assets through that full year-long or longer process and make your beneficiaries wait to receive their assets until that whole process is completed when you could have those assets going out to them a lot quicker? So the easiest way to achieve that result is to structure the way you own your assets appropriately. And what I mean by that is what happens to your assets when you pass away, whether they have to go through probate or not, is going to be dependent upon how you own your assets. And not so much do you have a will or do you have any other types of documents in place. So that's why the first step is always to take a real careful look at how you own your things, because you may already own them in such a way that they are going to not have to pass through probate when you pass away. And by way of explanation, one of the most common ways to avoid probate is to have assets that are owned jointly. So particularly when I'm talking to married couples, a lot of assets that you've accumulated over the term of your relationship by default tend to be joint. You bought your house jointly, you opened bank accounts that were joint, you have your cars in joint names. So all of those joint assets upon the first of you to pass are going to pass automatically to the surviving co-owner. So they don't need to pass under a will. They don't need to go through probate. It's really a quick, easy transition of ownership of assets to the surviving co-owner. So again, one real simple, easy way to keep assets outside of probate is to structure them such that they're owned jointly. A second really easy way to make sure assets stay out of probate is to make sure they have a named beneficiary on them. And this largely applies to financial accounts. So IRAs, 401ks, annuities, your checking and savings account at the bank, life insurance policies, all of these accounts are set up so that you can put a beneficiary designation on them. And sometimes not all financial institutions just blanketly call them beneficiary designations. Sometimes you may hear the term POD, which means pay on death, or TOD, which means transfer on death, but they all function the same. It's you fill out a form with the financial institution that holds the account or holds the life insurance policy, and you say, when I pass away, these assets are to go to my spouse or to my kids or to my partner or whomever it is that you want to receive those assets. So when you pass away, if you've completed that form and named a beneficiary for that account, those assets are going to pass directly to the beneficiary that you've named on that form. So just like with joint ownership assets, it's not going to need to pass through probate. It's not going to need to pass under your will. So it speeds up the process. And again, it's a really quick, easy way to transition ownership of assets out to your beneficiaries. So there is one other way that I always talk about that you can avoid probate, which is by use of trusts, but that's a kind of another really in-depth topic that I have another video on. So today I'm just getting more into detail about just those beneficiary designations and joint ownership. I do want to make one clarifying point that with joint ownership, there's kind of one little exception when it comes to real estate that may not guarantee you're automatically going to get real estate upon the passing of a co-owner, because when it comes to real estate, there are two types of joint ownership. There's tenants in common ownership, and there's joint tenants with survivorship. Joint tenants with survivorship gets you the result that I had mentioned before, where ownership is going to pass automatically to the surviving co-owner when you pass away. And this tends to be the default when, for example, spouses or partners own property together, because that's the result really that you're looking for. You say, when I pass away, it should all go to my spouse or to my partner. So, but that answer isn't necessarily the default when it's siblings that own a property. So say your parents have gotten older or they've passed away and they've left you and your siblings a house. Maybe they've left it to you as tenants in common, which is that separate type of joint ownership. And tenants in common is different because with joint ownership, it's essentially both parties own the whole. So when one of you passes away, just one person's name is essentially removed from the title and the 100% is owned by the surviving co-owner. With the tenants in common, I always tell people it's like you've taken that asset, you've taken that property and essentially put a chainsaw right down the middle and cut it in half, such that you own, for example, if you own a house with your sibling and you each own half, you own your 50%, they own their 50%, and it's deemed to be an individually owned asset. And that means it's going to have your 50% of the house, if you pass away, does have to go through probate and is going to pass under your will or under the rules of your estate and not just pass automatically to the surviving co-owner. So I do always like to tell folks, if you own real estate jointly, take a close look at your deed and confirm if you own it in survivorship or own it as tenants in common. But in summary, again, if you're looking to avoid probate, there are a lot of complex legal tools that I have at my disposal that I can help you do that. But the simplest ones that a lot of times don't even require an attorney to be involved is to make sure assets are owned jointly or that they have a named beneficiary.